Okay, well, good morning. It's great to see all of you here at this last of our speaker events for this year. I'm Dwight Newman, and it's been my privilege to be chair of the college's speakers program this year. I know you're here for the main event that will start in just one moment, but just because this is the last speaker event of the year, I wanted to note my thanks to several people. Though our work still includes further work to start off next year's program, this is a good chance to thank publicly those who've contributed to the program, and thanks especially to Chris Harris and Melanie Stevenson in the offices, who week after week have provided great support to the program on the organizational side. Thanks to Jennifer Malloy and Luke Muller, who filled in for her during her maternity leave. As our development officer, she did double duty in the context of also a lot of organizational work on the named lectures and some general thinking around speakers. I also thank Kate Blau and Mike Sibley, who've helped with the videos and different organizational matters. The faculty members on the speaker committee who provide guidance and suggestions, that's Brent Cotter, Mary Eberts, and Marilyn Poitras. And a big thanks to Drew Gillespie and Kathleen McLean, who've been the student representatives and been here week after week to help thank our speakers, and who will be helping to shape next year's speaker program as well. We have today's speaker here today thanks to the funding of the Cronkite Lecture Fund. Dean Cronkite, whose memory that fund honors, joined the faculty here in 1924 and served as dean from 1929 through to 1961. On his retirement after that 32-year decanal sentence, the Saskatchewan Bar Review described his achievement of an academic law school emphasizing law as a rational discipline deserving the attention of fine intellects, that hoped to graduate students with feet on the ground but eyes for the stars, who could both serve practical needs of the profession but also reach to the highest aspirations lawyers can. As the Bar Review continued, it was this aim which led to the playing down of techniques and practice and to the spotlighting of theories and jurisprudence. It was this aim which also explains the Cronkite belief in maintaining a faculty of professors of opposing schools of thought. The conflict between them could be expected to induce intellectual interest among the students, and from the variety, some one approach might be expected to inspire each student. In this spirit, today's lecture by Professor Edward Rock takes as much the form of a workshop as a lecture. Our speaker will talk for around 30 minutes, and we hope then to encourage discussion and even vigorous conflict about ideas. Our speaker is keen to hear your reactions and your challenges. A number of paper copies of the executive summary of the paper have circulated within the room, and some of you received copies of the draft paper if you're on a list where you got that. If you didn't and you're particularly interested to read the draft to send comments to Professor Rock, you can send me an email and I'll send you a copy. It's wonderful to have with us today Professor Edward Rock. He's Saul A. Fox Distinguished Professor of Business Law at the University of Pennsylvania. He also holds a professorial appointment in the Wharton School of Business. He's written many award-winning articles, published extensively in top journals, and co-authored the widely regarded book, The Anatomy of Corporate Law, A Comparative and Functional Approach. He's widely regarded as one of the top academic experts on corporate law and corporate governance in the United States, and in that area it follows in the world. He started his university studies actually in physics at Yale, which I was reminded of when I tried to explain the synchrotron to him yesterday and fumbled about and then was told he'd worked in an accelerator facility before. He completed his next degree at Oxford University in its PPE program, Philosophy, Politics and Economics, and then pursued his law studies at Pennsylvania, where he went on to join the faculty. And we're delighted that he's accepted our invitation to speak with us today. And without further ado, it gives me great pleasure to welcome Professor Edward Rock.
It's a great pleasure to be here. It's good to see students in the audience and good to see that Canadian students gravitate towards the back of the room the same way my students at Penn do. My students at Penn never believe me when I tell them that I always call on the students in the back of the room because they speak louder, everybody can hear them, and that if you actually want to hide, the first couple of rows are the best place to hide in at least my classroom. What I'm going to present today is very much of a work in progress, and I very much am looking for help on it. It is an attempt to push American corporate law beyond what I consider to be a very tired debate. since Burley and Means in 1932, it, I think, is accurate to say that the master problem for U.S. corporate law has been the divergence, the separation of ownership and control, the divergence of interest between shareholders and managers. And that has been the focus for generations of corporate law scholarship. In 1976, with the Jensen and the justly famous Jensen and Meckling article, we started putting a finance sort of frame on the issues and started talking about shareholder manager agency costs. But in essence, shareholder manager agency costs were just a way of repackaging the old separation of ownership and control. This piece fits within a research program that I've pursued with Marcel Cahan over the last 10 years or so, in which we, in various articles, have made the argument that over the last 30 years, the classic shareholder manager agency cost problem has been largely controlled, and it's been controlled through a variety of devices that we refer to as adaptive devices. Incentive compensation, board independence, more independent directors, the rise of active shareholders, and with all of that, a change in how directors understand their responsibilities. And we'll go into this a bit more in a moment. If we're right that the world has changed, that the shareholder manager agency cost problem has been largely controlled, then the question is, what should corporate law be worrying about? What is the next set of projects? Personally, one of the things I think is an important project is thinking hard about the relationship between firms and the newly empowered shareholders. And I have a piece coming out in Cornell looking at that and trying to integrate what is generally referred to as investor relations, something that all public corporations now pursue, and corporate governance. Another direction to go is to look at the remaining pockets of managerial agency costs, and in particular small publicly held corporations which don't have analysts following them, that are not exposed in any significant way to any sort of market for corporate control, are an area where Professor Cahan and I think that there remain substantial agency costs. This paper goes in a somewhat different direction. Let me remind you of something that I say to my students in the basic corporations course, but they don't listen to me very much on this because of how American law is developed. But I know that in other systems, corporations courses, business organizations courses start with not just one agency cost, but three agency costs, or three significant divergence of interest: shareholders versus managers, controlling versus non-controlling shareholders, something that obviously is quite prominent and important in the Canadian context, and shareholders versus creditors. What's critical to understand about these three agency problems that I think are the three agency problems that corporate law deals with is that they are interrelated. What I mean by that is that when you have high managerial agency costs, when managers act like fixed claimants, in doing so, they protect the interests of creditors, because in fact they are, in a significant degree, creditors. And when shareholders are dispersed and passive, they can't control the managerial agency costs, and the creditor concerns largely slip from view, which is what I think has happened in the United States. The question is, if you then have controlled those managerial agency costs, what implications does that decline have for the shareholder creditor agency cost problem? So there are really three starting points for this paper. One is the link between shareholder manager agency costs and shareholder creditor agency costs. The second is a comparative point, which is that countries with strong shareholder-centric corporate law, which is to say most countries other than the United States. Countries with strongly shareholder-centric corporate law also typically have significant corporate law-based creditor protection. And finally, I argue that the US has evolved towards a shareholder-centric corporate law, but it's done it not through change in law, but through change in practice. And if it's done through change in practice, then it seems to me you have to ask, what, if anything, should the law do in response? How do we adapt to this new set of problems? So let me quickly run through the classic shareholder manager agency cost story as it has been developed in the post-Jensen and Meckling years in the United States, that is to say since 1976. Why do people think, why do all of my colleagues in corporate law nearly think that there is a substantial shareholder manager agency cost problem? First is an incentive story that people tell. That managers are paid fixed salaries, they're paid cash compensation and cash bonuses, whereas shareholders only benefit by the residual cash flows of the firm. Therefore, there is a divergence in incentives between the managers and the shareholders. Second, people talk about, and Jensen and Meckling are the ones who coined this phrase, the free cash flow problem. They observed that firms retain cash well beyond what they need to fund profitable investments. Why might managers who are looking for a quiet life retain cash? Well, you get to use it to have an air force, you get to use it to pay yourself high salaries and so forth. Third, people argued that you saw managerial empire building. You saw firms buying other firms, not because they were good investments for the shareholders, not because it increased shareholder value, but because managers of big firms get paid more than managers of small firms. How do they get away with it? In the classic story, they get away with it because shareholders are dispersed, they're passive, and the managers have captured the board of directors by appointing their friends. And you see it, they argue, that whenever there is a contest, an offer to buy the company at an above market price, the managers resist. And a final element of the story is that when you look at what happens when companies go private in leveraged buyouts, the premia are huge, and those large premia are viewed as the capitalized value of these managerial agency costs. Well, what's happened to that story over the last 30 years? Let's start with the incentive story. Since the early 1980s, really accelerating since the early 1990s, incentive compensation for CEOs has skyrocketed. So now, instead of CEOs being paid a cash salary, they get a lot of their compensation in stock and options. They have change in control agreements where they get paid 3 times salary and bonus in a change of control. And now, when you look at the incentives facing the typical CEO of a public company, taking into account both stock owned or equity substitutes owned as well as current compensation. For the typical company, the CEO owns about $40 million in equity. Annual comp is worth about $5 million. And as I say, 2.99 times cash and bonus on change of control. What's happened to the free cash flow problem? Well, we've lived through 30 years of paying out free cash flow, of buying back stock. This chart here is net equity issuance as a percentage of stock market value since 1968 to 1999. And this is 1982. From the early 80s on, we've been net negative in equity, which is to say we've bought back more shares than we've sold shares in the market. This chart has stock repurchases. That's how we've done it. We've been buying back stock constantly, with the net result being that the number of AAA rated non-financial U.S. corporations has dropped from 60 in 1980 to 4 today. That is to say, the free cash flow has disappeared. It's been paid out. What's happened to managerial empire building? It's gone out of fashion in a very big way. Now, since the early 90s, the fashion has been focused, has been to sell off unrelated businesses, to buy businesses in a field, in an area in which you actually know the managers know something about managing it. And it has continued, this story of focus has continued since 1980 to the present. It is now just part of the received religion. And what's happened to dispersed ownership, passive shareholders, and captured directors? Well, it's all changed. The US market, around 70% of shares are held by institutional investors. That is to say, pension funds, mutual funds, insurance companies, charitable trusts. We've seen the rise of activist investors, hedge funds who have taken an interest in corporate governance. The hedge funds often have investments from those institutional investors. It works better for the institutions to have hedge funds do the heavy lifting and to provoke the ire of management than it does to do it themselves. We've seen the rise of proxy advisory firms, ISS and Glass Lewis, who are a counterweight to management, who advise institutional investors and who institutional investors follow. And as a result of that, directors' understanding of what it is they're supposed to do has changed. Like it or not, as business school put it, shareholder value maximization is the religion of the boardroom. In terms of managerial entrenchment, we've seen the disappearance of staggered boards. They've almost entirely disappeared from the Fortune 100. They're rapidly going out of fashion in the Fortune 500. Lucian Bebchuk, who is a very active shareholder activist who also teaches at Harvard Law School, I saw recently they have a new clinical program called the Shareholder Rights Project, where they have students now file shareholder proposals at various companies to de-stagger the board. I sort of have a vision of this New Yorker cover of the institutional shareholder sitting next to the indigent and the others who use the Harvard clinics. But the truth is, takeover defenses in the United States are utterly irrelevant. Why are they irrelevant? They're irrelevant because of the incentives that the CEOs have. Think about the incentives if you have $5 million annual comp and you have $40 million of stock and you have a 3 times change in control agreement. Somebody comes along and offers you a 20% premium for your company. You're a 64-year-old CEO. You're going to be leaving when you're 65. The key question from the CEO's perspective is, should I stay or should I go? If you look at the incentives that we have given CEOs, if they stay, $5 million annual comp for another year or 2, or I can go and cash in my chips and go skiing, right? So the premium on my stock, my $40 million of stock, is $8 million. My change of control payments are $15 million. All of my unvested options vest. I get to cash those in. Total, if I go, $23 million. This is just a for instance, but it characterizes many companies so that on a financial basis, we have given CEOs huge incentives to say yes to an offer to buy the company. Premiums for LBOs have gone way down. When you put it all together, one way of understanding what's happened in the last 30 years in American corporate governance is that shareholders have bought out managers' entitlement, if you will, to their jobs. Or to put it differently, shareholders, through these contracts, have paid managers enough to get managers to do the right thing. And the beauty of corporate law is that what it costs to pay the managers to do what they should have been doing all along anyway as fiduciaries is trivial compared to the amount that shareholders can make by managers doing the right thing. That's what makes corporate law work. Is most ordinary people will do the right thing if you give them an incentive of the sort I put on the board, $23 million to do the right thing. And that allows the shareholders to get access to premium change of control transactions. The problem is, though, that as we have aligned the interest of managers with shareholders, all of a sudden managers start to think like shareholders. And if you think like shareholders, then all of a sudden you have to worry about creditors. Because shareholders have a natural, if you will, a natural incentive to externalize risk onto creditors. It's just the nature of the relationship. Creditors have a fixed claim on the firm. Shareholders have a variable claim on the firm. And so there is an incentive to externalize risk onto the creditors. And you can think of the shareholder creditor divergence in three different types of activity. One is asset dilution, which is a fancy way for saying siphoning assets off to shareholders. Second is substituting risky assets for less risky assets, asset substitution. And debt dilution is adding unanticipated new debt. The silver lining of the free cash flow problem was you didn't have to worry about any of this. The firm's sitting on a pile of cash. You don't worry if you're a creditor about being paid. If it's not, then you do have to worry. And the question then is, what do you do? How do you adapt? How does corporate law adapt to this newly salient problem? And you can do it through contracting, you can do it through compensation, you can do it through governance, and the last element will be, as a backstop, you can do it through the law. In terms of contracting, the question, this part of the paper is very much unfinished, is how should bond contracts be changed to better take into account the shareholder-centric nature of corporate governance? And as I say, that's still a blank canvas. I'm still trying to learn enough about bond contracts and how they work to have a view about how they should be changed. One thing you know now, and here is where hedge funds become extremely important. If you put into the bond contract any sort of rights for individual bondholders, they will be used. Right? The interesting change in the world brought about by hedge funds, and Greece has discovered this, Argentina has discovered this in the sovereign debt world, is that bond contracts are read, they're read very carefully by hedge funds who have the wherewithal to pursue bondholder rights to the extent they can, and they do. So as a design feature, the question is, what sort of individual rights do you want to put in order to harness the hedge fund's high-powered incentives to protect creditors more generally? Compensation is a fascinating and interesting direction for aligning the interests of shareholders and creditors here. Okay? How so? Well, incentive compensation, as I briefly described, was the way we fixed the shareholder manager agency cost problem. We turned managers into folks who would think like shareholders by giving them a whole lot of equity. We may have given them too much equity, but it's one way to solve the problem. Incentive compensation is incredibly powerful. If you go back to the original Jensen-Meckling article in 1976, there's a little paragraph in the end that says, people have asked us, wouldn't it also solve the shareholder creditor agency cost problem, which they describe in the piece, if managers held the same claims on the firm or held claims on the firm that had the same mix as equity and debt in the form of inside debt? That was the question they were asked. And they said, yes, we agree. It's a good question. It would solve the problem, but we can't figure out how to integrate it into our model. And so they left it alone. Fast forward 30 years. 2005 in the United States, the SEC requires for the first time the systematic disclosure of pension obligations to top managers and deferred compensation by top managers. Okay? Pension obligations and deferred compensation are both claims on the firm. They are debt held by managers. They are inside debt. And the availability of this new evidence, of this new data, triggered the interest of a variety of finance economists to focus on the incentive properties of combining equity with inside debt. Alex Edmonds and Wharton revisited the original Jensen and Mecklin question and modeled it, came up with a formal model that allowed him to examine the properties. David Yermak at NYU and a variety of his co-authors have been pursuing this, and the results are exactly what you would predict. So that when managers hold substantial inside debt, the likelihood of bankruptcy goes down because they're fixed claimants. That the higher, when the CEO has a high ratio of inside debt to equity, lower cost of debt to the firm. Again, because creditors perceive there's less likelihood of insolvency. Fewer bond covenants when the CEO receives more of their compensation in debt than in equity. You can see the results in the bank credit default swaps during the financial crisis. Banks where the insiders had a higher ratio of debt versus equity performed better, were less likely to fail than banks where the CEO had supercharged equity compensation. Okay, so it works. Now, what is the exact right mix of equity and debt is an interesting design question that finance guys are working on. Turns out you don't have to track the exact debt-equity ratio of the firm. You can be pretty rough and ready about it because so long as the managers have a big inside debt position, they're going to worry substantially about bankruptcy. Okay. What about governance solutions? Historically, in traditional bond indentures, that when certain covenants are triggered, the creditors get to appoint directors. One question that comes out of this is whether that should be expanded, whether it makes sense to write into the covenants greater appointment rights. Again, I don't have a view on that. I'm most interested really at this point in turning to what the legal backstop is in American law if these other mechanisms haven't worked. So think about the following hypo. Suppose Target Corporation is in the process of being sold. And they've surveyed the market. They've done a great job soliciting bids. And they've attracted a super high, highly leveraged bid from some third party. Target senior managers have substantial equity stakes through ownership of stock and options. They also have inside debt, but their plan is to cash out. Once the deal's done, they're gone. They're going to sell basically their equity and their debt in this wonderful sky-high transaction. In the course of the sale process, they have directed the development of new projections, different from the projections that the company had been using to manage, new projections to help with the marketing effort of the company, which to an impartial eye we can assume look wildly optimistic, maybe even on the verge of fraud. Moreover, let's assume, and I'm making these facts intentionally extreme because I'm trying to see what, if any, creditor protection is built into American corporate law today. The board, we can assume, is aware that management prepared these projections, that it had an incentive to inflate them, and that they were inflated. And moreover, that the buyers and their banks were relying on them to some extent. Now, everybody knows projections are optimistic. All the banks are unnoticed. The question is, how optimistic do you think they are? And there's reason to believe, in this case, let us assume that the banks were misled. Now we get to the critical moment. So on the eve of either approving the transaction or approving the closing, or going to closing the transaction, suppose at the board meeting, the bankers for the target, the investment bankers for the company, in a moment of candor, tell the directors that as soon as the deal closes, the company will be insolvent, and the pre-LBO creditors will be high and dry. Okay? Given the price the buyer is paying for the shares and the amount of debt it is putting on the company and the likely cash flow, say the bankers, there's no way it will survive. You're all lawyers. So what advice does counsel for the company give to the board? This is a deal the shareholders love it. This is a sky-high price. This is a higher price than they ever thought they'd get for the company. This is a fantastic price. Can the board, under these circumstances, go forward? Now, I don't know a single business lawyer who would let the board go forward under these circumstances. The question is, why not? That's the question. If you really believe that the board's only duties are to shareholders, and here the shareholders are getting a higher price than they had ever expected to get, if you believe that that's the board's only duty, then the board's duty is to go forward. And yet, no good business lawyer will let his or her directors close if the lawyer believes the result is immediate or fairly immediate insolvency. And the question is, why not? Quick comparative divergence, okay? The UK has extraordinarily shareholder-centric corporate law. Shareholders can call a general meeting. In the US, Delaware shareholders have no right to call a shareholders meeting. If you get 40% of the shareholders who request a meeting, you still can't call a meeting under Delaware corporate law unless the board agrees to it. Okay? Under UK company law, the shareholders can act in the general meeting. Whatever they decide for the company, in essence, is going to be binding. They can remove directors. The UK takeover code prevents anti-takeover measures by the board, no frustrating action. And you can't even prefer one bidder over another by providing financial assistance. And yet at the same time, and this is my point about the link between a shareholder-centric system and creditors' needs, at the same time, in the Insolvency Act, the UK has a wrongful trading provision, which imposes liability on directors for approving transactions that lead to insolvency. The exact language is that person knew or ought to have concluded that there was no reasonable prospect that the company could avoid going into insolvent liquidation. Liability will not be imposed if the court is satisfied that after the condition specified here was first satisfied in relation to him, the person took every step with a view to minimizing the potential loss to the company's creditors, as he ought to have taken. Okay? The the failed LBO that I described would fit easily within the UK's wrongful trading statute. Because the directors, as I described the facts, they know there was no reasonable prospect that the company would avoid going into insolvent liquidation, and they didn't take any steps to avoid insolvency, and hence no steps. They certainly didn't take every step with a view to minimizing the potential loss to the company's creditors. Now, how then do you do LBOs in the UK? Because they had an active private equity industry. The answer is they're less leveraged. The board, I'm told, by experienced UK lawyers, the board will not approve a leveraged buyout unless the company's investment bankers will provide a solvency opinion. We'll say, as far as we can tell, examining all the facts and circumstances, the company, after the closing, will be solvent. The liability for directors for breach of wrongful trading is not catastrophic. It's within the discretion of the court. It's never very large. But nonetheless, they're terrified of it, in part because of the reputational effect. The small possibility of wrongful trading liability has led to much less leveraged transactions, has led to the directors taking seriously the obligations to the creditors. How do we do it, and how do we handle it in the United States? Well, as you know, in the United States, bankruptcy is federal, whereas corporate law is state. So it's the Delaware Chancery Court which regulates solvent corporations, but once an LBO fails, the company's bankrupt, it ends up in bankruptcy court. And in bankruptcy court, failed LBOs primarily are handled under the old doctrine of fraudulent conveyance. And it takes a while to figure out exactly how fraudulent conveyance can fit a failed leveraged buyout. Because it's not immediately obvious. There are two claims you can bring on a fraudulent conveyance theory. Now let me take a step back. Fraudulent conveyance comes from the Statute of Elizabeth, originally had as its target the problem of the farmer who is about to become insolvent, who sells his sheep to his brother-in-law for a pittance, because better that his brother-in-law has the sheep than that the creditors get the sheep. Okay? And in those circumstances, the creditors complain that they should have gotten the sheep. You can't give away the sheep to your brother-in-law if you owe money to your creditors. And the point of fraudulent conveyance law historically has been to unwind the transaction between the farmer and his brother-in-law. Force the brother-in-law to give back the sheep so the creditors can get the sheep. Okay? When you try to apply this to leveraged buyouts, it takes a while to figure out how to do it. So there are two potential theories. One is to examine the payment to the shareholders. In a leveraged buyout, it's normally structured as a triangular merger. Everything closes at once. The buyer ends up with the company. The shareholders get cash. And the debt used to finance the LBO is secured by the assets of the firm. Okay? So one thing is to look at the payments to shareholders and to say no value received. That's a payment without receiving equivalent value that leaves the company insolvent, ergo fraudulent conveyance. Now, the problem with that in publicly held corporations is getting the money back. Almost all shares in the US are held in nominee name through several layers of ownership. If you say that the record shareholder has to return the money's already gone on to others, and you can bankrupt some of the intermediaries if you require that they pay back the money. Congress, for better or worse, found this a convincing argument in 546E of the Bankruptcy Code, said that all security settlements are exempt from avoidance. So as a practical matter, the fraudulent conveyance claim against the shareholders doesn't work anymore in bankruptcy court. The second one is against the banks that financed the LBO. So what is the, when you're now looking at the banks that finance the LBO, what are the sheep? What is the transfer from the firm to the LBO financing banks? And the answer is, it's the promise to repay. The firm promises to repay the banks for the money the banks lent. It's the promise to repay. And what did the firm get in exchange for that promise to repay? It got nothing. All that money went to the shareholders. They got nothing that they could invest in a new plant to drill for oil, to market a new product. The company got nothing in exchange for the promise to repay. And so in a long series of cases, now these go back into the 1980s, it became customary to view that promise as a fraudulent conveyance, with the remedy being that either the LBO banks are demoted in their seniority to the pre-LBO creditors, or even eliminated, put after the pre-LBO creditors. Now, as a functional matter, what are we doing here? What we're doing here is it's not that the LBO banks have done anything particularly wrong. They're in a competitive market for financing, and they lent on market terms. What we're doing in that circumstance is to recruit the LBO lenders to protect the interests of the pre-LBO creditors. But note, neither fraudulent conveyance theory tells you anything about director duties. To a corporate law, corporate governance perspective, that seems very odd, because the directors could have prevented the whole thing. The directors were in the center of it. They had the information, or could have gotten the information. And the idea that we're going to recruit later creditors to protect earlier creditors, when in general we say creditors don't owe any duties to other creditors at all, seems odd, and certainly seems odd to be the only way to control these highly leveraged transactions. So what are the director's duties in these circumstances? Here, when you plunge into Delaware corporate law, there are several theories. One is you can characterize the LBO as in fact a share repurchase. And I'm sure under Canadian law, just as under Delaware law, a share repurchase that renders the firm insolvent is illegal. And under American law, it results in director liability that cannot be exculpated under 102b7 of the Delaware statute, which provides for the insulation of directors from liability for violating the duty of care. Alternatively, you can characterize it as an illegal dividend. Very similar sort of theory. A dividend that renders a firm insolvent is improper. Maybe you can fit it into the duty of loyalty, given the current understanding of the duty of loyalty, which is now, at least in some judgments, viewed as consciously and intentionally disregarding their responsibilities and adopting a we don't care about the risks attitude concerning a material corporate decision. Here, approving this highly leveraged buyout without the corporation getting any benefit from it, as a doctrinal matter, can be put within the duty of loyalty. And finally, there may be a duty to legality claim. It is said that's part of the director's fiduciary duties to obey the law. The scope of that duty is highly uncertain because there are so few cases. The cases there are primarily apply to public law sorts of things. No bribery, can't have the company engage in price fixing. Clearly does not mean that the directors are liable if the company breaches a contract. And so here the question, again, entirely absent from the case law, is whether approving a fraudulent conveyance falls on the public law side. It sounds in fraud, as it were. If you emphasize the fraud roots of fraudulent conveyance, you can make an argument that it falls on the public law side. The question is whether the law should do more, or whether the resources within the Delaware system in existing law are sufficient. And here we come up to one of the real problems that the US has in adapting to this new reality, which is precisely this divided architecture, where all of the cases that pose the really interesting questions come up in bankruptcy court in front of bankruptcy judges who have no particular expertise in Delaware corporate law, no particular interest in it, and have much more important things to do than worry about the fine details of director liability. They have companies to get out of bankruptcy, and they have to figure out which of the directors get paid, which of the creditors get paid, and how much. By contrast, Delaware courts, which indeed do have authority and expertise, get only a very small number of cases, some of which pose shareholder creditor issues, but in the most bizarre and unrepresentative sorts of circumstances. And so the question is, what can they do? What should they do, or should we just leave it alone in terms of the court's expanding involvement? And I don't have a settled answer on this. Maybe in interpreting bond covenants, they should have a more suspicious stance towards managers when they have some sense that what's going on is the externalization of risk onto creditors. Maybe the bankruptcy courts should send more cases to the Delaware courts for advisory opinions pursuant to the certification process that Delaware has. Or maybe they should just say, take all of your director duty claims over to Chancery Court. We won't handle them in bankruptcy court, but then you get the obvious waste of effort of having two courts having to deal with issues rising out of the same set of facts. So let me stop here and open it up to questions and comments.